Simon, if you can't suggest that the courtroom is just being open now for access for many individuals who are seeing actually standing and waiting at the doorway of the High Court room number 31, where the application for this candidate is going to be charged like to tell the judge sees that is supposed to start in a few minutes from now. But that's the judge that is at the 9th, because right here, lawyers arrived a long time ago and be able to see the honorable secretary and many of the lawyers actually, if Chitingo can show you around, Chitingo can be able to show you around, you can be able to see the prison officers here. We expect probably
nange tuli mu kuyingira kati mu kooti era kyolina omanya check-up ziri mugendera ddala mu maaso wano bulungi aliko ku Extreme Media UG. All you need to do is subscribe. Kaluyi ne kanso kalole naye wuli atuuse ali mu bulungi obumusoma n'amateeka okuva e Kenya naye nga byampaka temulina okumanya ebintu byampaka. But all you need to do is subscribe, like nga atera commentinga naye ng'embeera bweti bweri sharinga video mangu tulabe ekigenda mu maaso. Empaka okuyingira tebibadde byampaka wano ku mulyango era nga kuli abantu bangi wane nnyo people very many here. Embeera bweti bweri naye nga Dr. Kizza Besigye aleetebwa wano ku kooti sharinga tutambule mpola mpola. Omulungi ali ku Extreme Media UG era bweti bweri wane nnyo. Banamateeka bamazima go bangi ekifaananyi kirungi ekifaananyi kiri stayed out. Is the image okay? Is the photo okay? All right, we need to get where to sit. is the kifaananyi okay? Kale alright, kale bino kyekyo ekigenda mu maaso wano eno munnange aliko essaawa zino. Bakasozi bangi nnyo ddala. Gwe oluyiti gwe kyeyalinga bukyeyalinzi ebisigadde obireke. Kyeyalinga twewaayo nga for extreme media yugi okuba ntukubatuusaako buli kimu ekinaba kigenda mu maaso mu ggwanga, whether politics oba entertainment, era nga bwobawulira essaawa zino bannamateeka baabo we bali nnyo. Yes. Era akakooti kalinga akajjudde kubanga amazima akakooti katono, ekooti ntono mulungi aliko essaawa zino eringa etagenda kubanga Magenzi, okay, thank you for appreciating. Okay, thank you for appreciating you people. It's not easy. It's not an easy thing. But remember, we've been doing this story. We've been following up okuva nga akyatwalibwa eri mu court martial. Tubadde tugikola, tubadde tufollowing okuva nga akyatwalibwa eri mu court martial. So nereno tusazeewo okuba tufollowing up. Embeera bweti bweri omukulu aliko kati essaawa zino nga ateera buli commentinga ebisigadde obitulekere bulungi aliko. Abasirikale mu bali mu kwetala wano eno mpola mulungi aliko essaawa zino Uganda wano. Embeera bweti bweri omulungi media yudi subscribinga likinga ateera commentinga kotiyo. Thank you so much. Koti tendaba kutandika era tugenda kubanga mazima gutukuwa buli kimu ekinaba kigenda mu maaso. Bannamateeka bano ebamukulukiza Besigye bali mu kweteekateeka mpola. Tugenda kubatandika. Alright bro, thanks for appreciating.
And the judge obeyed versus Attorney General and the Commissioner.
The media have checked all the pictures and video footage, but please not my face.
Today's what? Alright. Omulamuzi agambye tayagala feesi ye erabike mu kamera. Musajja agambye tamulaga feesi. Sigalawo ngenda sigala ngayinza omulamuzi agaanye okuba nti akwata
Also holding is captured by our man. Also holding him for one of the years to work on. He's on his way. The Honorable Mayor Segona is on his way. I'm holding everything for them. That way they are here, they are on the record. My Lord, we have Ernest Malibala. My Lord, we have Council Secretary Baker. We have Council Wanda Samuel Roller. Council Boy Ivan. Council Katumba Apollo. Council Chief Michael. Council Kato Wilson, Council Paul Silas, Council Farouk Kamnegia, Council Abshale, Ronald, Council Anointed Peter, among others. For the record, and the leader of the team, Senior Martha Karua, is attending court today, pending approval for certificate to appear this matter, civil election. But she's in attendance, my Lord. She doesn't
In attendance, my Lord.
as the guest.
And leading us. And my Lord, I'll invite Honorable Tobias who has joined us to lead the next proceeding. But we are concerned that we don't see our fires.
I just want to deal with that when he appears, then I get communication. Then we shall understand.
My Lord, allow me to seek Honorable Elias.
Please, my Lord. Just to address you on the issue of the team leader, our senior counsel. My Lord, she got a temporary practicing certificate to handle Dr. Kiza Besigye and the matters, either put pending before the General Court Martial. My Lord, the construction of that PC, in our opinion, is that until those matters are conclusively handled and any other application arising out of those matters, she still has that audience, my Lord.
That's your construction.
Yes, my Lord.
At least I know you know the proof that you are constructing this. But that shouldn't be a serious matter. It should be. Any other council who wants to go? Yes, yes, I can see Honorable Sir. He is on the record. Number 2 on the record. So I was just waiting for the person.
Dr. Kizza Besigye huyo wansi, as you can see, ava kutuka kati. Huyo wansi Dr. Kizza Besigye ava kutuka kati. Huyo wansi tetusobola kugenda wansi, we can't go down. Tetusobola kugenda wansi, huyo atuuka. Dr. Kizza Besigye
My Lord, with your guidance, do we proceed to make the effort?
When the persons come in, I make some administrative orders and you can put this chair again. You go back. Our journalists cannot have success. The people who have coming. I don't know how we shall. Judge is saying
that
journalists judge cannot see the
ni vile muzambe bakasimu katondo
money bila wale
olaba
please. The lawyer will see after this
Let me stand here. We must not be in front of
reduce the numbers. He can't run. I'm telling you, I'm telling you guys. Too many, he cannot breathe. Reduce some of them. Let's hear from the judge. Listen to me. If someone cannot breathe, it means someone is unaware. So we're not going to hear someone who is unaware and then they fail in court. Now, administratively, prison authorities take back Colonel Kizabesi. We maintain with the lawyer. Take back.
My Lord, this is our prayer. No.
bagala kuzala bakutakiza Besigye bagala kumuzza
For them to come this way. Let's create a way. For me, once someone is sick, I'm not going to continue without passing anybody. I have to go back. That's clear.
By police.
Let him control us when we are in prison, not
Yes.
here.
Okay.
Can they remove?
Very simple.
We only have 2 minutes for this session.
A man came walking, bring him like this, and you are there masquerading as people.
The room is very small. The room is very small, and the soldiers are very many. Yeah, people are complaining. People are complaining.
Please, my lord, we beg to proceed. My lord, this is an application for habeas corpus ad substituendum brought under the provisions of section 38.
Break it down for our members.
That's the language of the statute, the act, my lord.
Yes, but you can break it down in similar.
Most obliged, my lord, this is an application brought under section 38 of the Judicial Act for this writ of habeas corpus, which is for an order that Dr. Besigye and Obed Rutale here be brought before you, my lord, for the respondent, to show cause why they are keeping them in detention without a valid remand warrant or any valid court order or pending charges against them. My lord.
I thought initially habeas corpus you are saying you don't know where this person is.
That's not the case, my lord. This
someone is in detention and we don't know who is holding him. Probably. So you need the body dead or alive. So the person is here. We are not.
Yes, my lord, but my lord, when you look at the strictly construction interpretation of section 38, it's not mainly restrictive that it has to be in cases where the person his whereabouts are not known.
So now the whereabouts are known. So what is the means of your application?
The application is for an order of release, my lord.
Now you add that.
Most obliged, my lord.
The body is here.
Yes.
So you add.
My lord, the brief facts are contained in the affidavit of the Honorable Winnie Yanima,
And I've read the
and we have read the affidavit. Most obliged, my lord. My lord, our prayer is grounded on that particular section 38 rather, of the Judicial Act.
of the 18 office in Courtroom. I'm very right. That's why I wanted
My lord, thank you very much. First of all, the speed with which you have acted. Number two, my lord, the summons is to the respondent to bring the body and justify why he continues in what we contend as unlawful detention. They have not shown up, but at least they have brought the body of the past, the bodies of the past. Having failed to come and justify the detention, I would implore you, my lord, before you go back to the administrative pronouncement, to order for release.
you are rushing that. You are rushing that. So can I ask all the journalists to move out? It's an administrative order. What I didn't want.
They have ordered for us to go out. Batugambye tufulumemu.
But if you don't want to go out, I can see that they can stay. We are not hiding anything. For me, as a judge, I'm very happy that our pastor and
parts, but probably the sticky part of the application has a little bit weakened. So what we have focused on is whether the continuous detention is justified.
Yes.
And probably a lot of damages of why that delay has been done. Now, thank you very much. I'm now going to take a break and ask the prison authorities to take back the 2 people. We are going to refuse counsel. I've told you, Mr. Karibara told me the law imposing around here to law.
Yes, my Lord, my big concern and contention is that when you order prison authorities to take them back, now they will be holding them under your order.
And that's why I had wanted to generally first leave us so that we do some housing. Because my friends from Law Society, in the were some
But my Lord, I was still proceeding with the application as directed by the board. Yes, ma'am.
Besigye bali mumuzaayo. Besigye bali mukubazaayo. They are taking them back.
I'm very excited about the restriction. So let's let that for
Banana batugobye.
We shall overcome someday. Deep in my heart, I do believe we shall overcome someday. 7 will die, 7 will die, 7 will die someday. Deep in my heart, I do believe 7 will die someday. And Mwozi will cry, Mwozi will cry, Mwozi will cry someday. Deep in my heart, I do believe Mwozi will cry someday. And freedom will live, Mr. will live, Mr. will live someday. Deep in our heart, I do believe Besigye will live someday. Justice will return. Justice will return someday. Deep in my heart, I do believe justice will return someday.
Freedom for all. Freedom for all. Freedom for all.
Bobi Wine naye waali. Kyagulanyi naye waali.
So never, never, never surrender. Never, never, never surrender. Never, never surrender. Never, never surrender. We shall never, never, never surrender. 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 Never,
kubanga abibanja omusiyafu ebyalo kikwata Speaker yali akwogerako
Now the principal is already here. It's principal. It's principal is already here. Principal is also here. Chakulani by Center, Secretary General plus the leader of opposition is also here. Mukulu Robert Chakulani Sentamu naye wuno wali Alright, subscribe if it's your first time here on Extreme Media UK. We are live in court, in High Court. Besigye is live in High Court. Bamulese mukoti naye bava mufulumya mu katondo. So if it's your first time here, subscribe, like, comment and share the link. Subscribing, liking, atera commenting. You're watching Extreme Media UK.
Yes, Mama. It's right here next to it.
Here, let me
otasise gwanga tuyingire muno. Alright, Besigye bamufulumizamuko bamufulumiramu era kooti bagyongezaayo for some minutes era agenda kuba nti akomawo just shortly. Abadde bagamba tufulumye fe banamawulire naye munange tuganiremu tugambe nedda kyekigenda mu maaso nga tetumanyi kyemwagala okukola nga tetumanyi so embeera bwetyo eri mu kooti wano naye nga bwe guba gagwe omulundi gw'okubeera ku Extreme Media UG subscribe nga like nga ate era commentinga bwe tulinda Dr. Kizza Besigye ne Munne Lutale okuba nti akomezebwawo. Engumi mu kooti
Mulanje sakachiti bahonarebo omwana oyo ana usike tukamani oza bamudipasi baba wamwe oza bakudipasi baba wamwe nda amanyi tona le bayimilide amanyi tona le bayimilide aligenda kuchuka muka tugenda chuka mu tugenda chuka mu
banange embeera bweti bweri subscribe nga like nga ate era commenting nga banange kakooti kajjudde kasibyeko kooti ejjudde kasibyeko esibyeko ejjudde kooti ntono kalumu katono era wetwogera Dr. Kizza Besigye ne Munne Lutale bamuzizaayo olwokuba nti abantu bo babaddemuko bangi abandi kubanga bali mukubantu banamawulire kyokka ffe nga tuli mu kugaanirawo embeera bweti bweri mu kooti naye nga ekyokwakemera buli subscribe like na video ate era mukendowooza yawo we are still in court. Run, how are you? Thank you so much. Get Extreme Media UG. You share the link. You are watching Extreme Media UG and Jogeza Nicholas aka John Paul UG is my name. Just share the link. Thank you so much for keeping it Extreme Media UG. You are all very many here. When I'm liking a video, when I'm liking it, that educa omsinga bwayiri. When I'm liking muri over, you are almost lukaga. When I'm liking it, chiba chibe. But it's a situation here, my people. We are inside. We are still inside. Just
naye no twazibyeyo wali naye tewaliyo no twazibyeyo omukyalo ndi munda mu kooti
So it's just my humble request, please, if you all like the video, all like the live, you like it, give me a like, so that it is in people, it is everywhere. We are inside the court. Besigye and Detainee have been taken out. Era kamera zimuliko wano ezimuvaaku engera bweti muganda wange I can see we are preparing to come back. When I'm liking the video, I'm liking the live and the chiva. tewali kigenda mu maaso kati kooti bagyongezaayo kooti bagyongezaayo naye ngaotambuza sheyalinga temadamu gyolekere buliko kandiwekala tukomyewo mu kooti
This is grounded on the provision section 38A, where this honorable court is called to jurisdiction and powers, my lord. In situations where the applicants are incarcerated without any lawful orders to, my lord, grant an order of unconditional release. And this is the provision, my lord, that the High Court may at any time where a person is deprived of his or her personal liberty, otherwise than the execution of a lawful sentence or order imposed on that person by a competent court upon complaint made to the High Court by or on behalf of that person. And if it appears by affidavit made in support of the complainant, that there is a reasonable ground for the complainant, court is given powers to give award and so on and so forth. The gist of the matter, my lord, is about court being satisfied that a person before court is detained without lawful orders. My lord, these facts are brought out in the affidavits.
Before you proceed, I think the AG will be representative and he formally be on the court. If I've seen badly, then we can proceed. If the police is involved, the microphones are accessible. You can speak from there. We have many lawyers.
My name is Johnson, where I'm a senior state attorney. Together with Matthew, Besigye, state attorney, and Jacqueline, the state attorney. We are sorry we are late because this matter was served on us late. and we had to ensure that we respond. We have filed our response in estimates, and we are ready to proceed.
Sorry. How many minutes do you need?
My Lord, on my part, I think 10 minutes would be enough, and then my colleagues will also come in.
According to the Attorney General's statement, it's not for a minute. The journalists have taken over the court and we allow you
My Lord,
This guy is had a problem.
it's our prayer that you will be pleased to find that Dr. Besigye and Roberto Vitale you go in cancellation given the fact that, my Lord, there is no evidence before you that there is any charge you further against them, or that there is any man warrant being issued by any court, or any lawful order given by court for the authorities in New Zealand to keep them in custody. My Lord, the affidavits which are borne out, the facts which are borne out in the affidavit of the Honorable Winnie Byanyima, as well as Counsel Proscovia Cornelia, are uncontroverted. There is no any evidence from the respondents, that is the Attorney General and the Commissioner General, controverting that evidence. And in Section 57 of the Prisons Act, my Lord, Section 57 is very clear of the Prisons Act, Cap 325. A person shall not be received or admitted into prison custody without a valid commitment or remand warrant, or order of detention, warrant of conviction, or committal. So that is the law, my Lord. And now, my Lord, the essence of habeas corpus is well explained in the decision of this Honorable Court in miscellaneous cause number 16 of 2021. Honorable Kyagulanyi Sentamu Robert, Babula Kyagulanyi Tungo versus the Attorney General and the Chief of the Defense Forces. On page 14, my Lord, a copy of which is going to be supplied to the court. Section page 14, this Honorable Court had the occasion to succinctly explain the essence of the writ of habeas corpus in the following terms. The purpose for a writ of habeas corpus habeas judiciendum is to review the legality of the applicant's arrest, imprisonment, and detention, and challenge the authority of the prisoner or jail warden to continue holding the applicant. The application is used when a person is held without charges or is denied due process.
Can we stop there, please?
Yes.
How did they end up in prison in the first instance?
My Lord, that is for the Attorney General and the Commissioner of Prisons to explain by way of evidence.
So for you, you have no idea.
My Lord, I will explain.
Yes.
My Lord, initially there were charges that had been preferred against them, as explained in the affidavit of Winnie Byanyima and the Proscovia Cornelia. My Lord, that is well explained. If I may go there, my Lord, to read the relevant paragraphs.
What is the explanation?
The explanation is that, my Lord, the defunct General Court Marshal had preferred charges against them. And on the 31st day of January, my Lord, this year 2025, the Supreme Court unequivocally pronounced itself on the constitutional.
Aaron Kiza is brought.
Never surrender, never, never, 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 never surrender, never surrender.
The conqueror of the court martial, Aaron!
He's on cuffs. He's on handcuffs. Remove the handcuffs. Remove the handcuffs. Remove the handcuffs.
Freedom for Aaron!
Aaron, the conqueror of the court martial!
The Lord may appreciate you. You had reached the stage of the court martial Supreme Court.
Yes, my Lord. What happened, my Lord? All the proceedings before the General Court Martial were quashed by the Constitutional Court, and my Lord, the decree to that effect was extracted.
Do you have it?
My Lord, I'm sure it's on record, my Lord.
But you have it. Take us step by step.
Yes, my Lord, we can, I may be granted more time from the 10 minutes I had earlier requested before, because I thought the court had addressed itself with this matter.
But you see, we have members of the media. This is very important for them to hear what the Supreme Court said.
My Lord, it is hereby ordered that
Number one,
the declaration of the Constitutional Court that Section 119, subsection 1G, now Section 117 of the UPDF Act, which provides that any person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense is unconstitutional. So that order is hereby set aside.
now in one line, take us. In one line, what is that paragraph in the statement? Our people.
My Lord, initially the Constitutional Court had held that Section 119, which is now 117, that has provided for a situation where civilians would be subject to military law if they abetted the commission of an offense by a serving officer, that was a valid law. They had not nullified those provisions. Now, that order of the Constitutional Court was set aside by the Supreme Court, meaning that Section 117 has now been nullified by the Constitutional Court. All charges, all ongoing criminal trials, all pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with the competent jurisdiction. 3.
Now, before you go to me,
Yes.
one line give us the essence.
All charges, my Lord, all charges, these charges are preferred by the DPP under Section 100, Article 120 of the Constitution. The charges before the General Court Martial are not sanctioned by the DPP. So the charges to be taken or transferred to the civilian courts pursuant to this particular order are those ones sanctioned by the DPP. As we speak right now, there is none, my Lord. There is no charge sanctioned by the DPP to be taken to the civilian court.
So, but in a sense, the decree indicates that there is a certain court not the civil court, not the civil field. Is that how I understand?
That they can, yes, my lord, a court of competent jurisdiction.
So address us very briefly whether I am a court of competent jurisdiction. Deal with that.
In regards to taking fully, this is not a court of competent jurisdiction. But in regards to the matters before you, habeas corpus addis abducienda, we are in the right forum, my lord. Yes.
Paragraph 3.
This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law. And this is not applicable to the applicants because they are not convicts. And finally, my lord, no, the second last one. All pending trials or partly hard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. It's also not applicable. It's for the serving members of UPDF. 5. Save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. That is.
So, very briefly, how many paragraphs are applicable in the motion before this court?
My lord, it is, as far as the matter before you is concerned, it's paragraph 1. Only paragraph 1, where, all right, my lord. My lord, the submission is that following this declaration of pronouncement by the Supreme Court, the proceedings hitherto pending before the General Court Martial under Section 117 of the UPDF Act became invalid. They were quashed, and there are no proceedings pending against the accused persons. And that brings us within the realm of the prerogative order of the writ of habeas corpus. We have already cited Section 57 of the Prisons Act, and also now the Section 38 of the Judicial Act. But now we are addressing you on the issue of curtailment of liberty and the remedy that court is enjoined to grant. No, my lord, we are given the nature of this matter, my lord, and the circumstances concerning the dire state of our client, particularly Dr. Kizabesa, his health status. We deemed it imperative that my lord.
At least I can go and read what was being thrown around the media. Okay, we shall come to and for me, I'm very clear that what has been written about is status different. 1 minute, the Lord
3 minutes, my lord. Most obliged, my lord. My lord, I've already addressed you on the question of liberty under the authority of Jaguar and the Babla Itungo. One aspect which I needed to point out in this actual authority is still on page 14. Liberty is defined by Black Law Dictionary, freedom from arbitrary or undue external restraint, especially by government. And this is, my lord, the import of the spirit of Article 23 of the Constitution, which guarantees liberty of Dr. Besigye and Obedi Lutare. In this particular case, my lord, under Article 23, first of all, they have not been informed of any offense under which they are, which they may have committed, and the reason why they are in New Zealand, and there is none. 2, my lord, Dr. Besigye has no access to a personal doctor right now for proper medical examination. And that is a very serious matter, my lord, because in as much as by a cursory look here, court can make one observation that maybe is improving. My lord, his state, the circumstances compare that an order be issued for Dr. Besigye to regain his liberty, to be able to access a medical facility of his choice so that he can be thoroughly examined to assess his health situation and get proper or specialized treatment. My Lord, the final authority I would like to cite on this one is Chwanka John and others versus the DP Director General of Internal Security Organization. It is miscellaneous cause number 9 of 2021, where again this honorable court resolved and decided that a writ of habeas corpus applies in cases of illegal detention and is meant to secure the personal liberty of a person under such illegal detention upon determination of the validity of such detention by the court granting the writ. I agree with the counsel for the applicant that preservation of personal liberty is crucial and should only be derogated from in exceptional circumstances where there are court orders, and that is the position of the law. So this particular law, my Lord, is reinforced by section 15 of the Human Rights Enforcement Act. My Lord, and this is where we are grounding our prayer. Section 15 of the Human Rights Enforcement Act of 2019.
Maybe to share some information with you, Council, there is a separate application grounded on the enforcement of human rights by a number of lawyers, and that file is before another judge.
Most obliged. Most obliged. Let me not go there. Let me sum up, my Lord, my submission under section 30. My Lord, it's our humble prayer. Now that the Attorney General and the Commissioner General have not in any way attempted to justify the incarceration of Dr. Besigye and of Eddie Butare, my Lord, you be pleased to order for their unconditional release, and specifically for Dr. Besigye to be able to access a medical facility of his choice so that he can be attended to by physicians of his choice.
Your case that I should make that order now.
This is the prayer, my Lord, that the order be made today and now, under the circumstances. And that's what a writ of habeas corpus is all about. Any continued detention, my Lord, would be again a further violation. And we wouldn't want to see this honorable court acquiescing in the violation of the rights of the accused person. And for one thing I need to emphasize, my Lord, is the 48-hour rule, which is very, very crucial and imperative under the Bill of Rights. So you can only curtail one's liberty within that period of only 48 hours. And to date, since 31st, Dr. Besigye have not been taken to any court to face any fresh charges whatsoever. So we pray that, my Lord, you be pleased to invoke the powers here, grant the prerogative writs, and have Dr. Besigye and Besigye released. We do so, my Lord.
Like I said, it's my former teacher, so we are trying to be nice.
Thank you for the courtesy, my Lord.
Kawulirize musomesa we. And it is Kalibala now presented. Kalibala.
But before we even arrive at this, I think there are two simple points that personal liberty can only be attained on the basis of some lawful order. That lawful order cannot be verbal. It must be documented. It must be demonstrated. Otherwise, the curtailment of that liberty is unlawful. And because of that problem, the unlawfulness, that's why we have this written as non-derogable. This writ has not always existed. It's the 1960 Constitution. It wasn't. But from the case of Besigye was 1966. It was recognized as a common law writ. It then came into the 1966 1997 Constitution thereafter, and was maintained into the 95 Constitution. But it has two lifts. One has been satisfied. And perhaps the most common one that has been satisfied is that the person has appeared here. But like in Injira's case, it was known where Grace Injira was living. It wasn't the case of, the common thing that was sort of disappeared. It was known where it was. Just like it is known where his applicants are. In fact, we don't say much because when they came here, they were in the company with other officers of the state who have a unique attitude. So we were able to tell their capacity. We knew where.
Tugenda kusaasaanya. Yasooka kwenza ekifaananyi kye ne kitalabika.
My Lord, the Supreme Court did not say that those who are incarcerated should remain incarcerated, except for those who had been convicted. One might argue,
for example, I was thinking we needed to consolidate this to application. So you are saying for Fred and Nikita, since he was convicted, so every
that case is actually different, and you will note when it comes out, it is a completely different. Those who had been convicted, unless they are not challenging the conviction, I believe my land friend is very vigorous. So there is nowhere in the judgment where it was said those who are in detention stay there until such a time that the government decides that it will find a competent court and transfer those findings. So this application is brought with that idea, my Lord, with that argument in mind.
I wish we can get a chair for the AG staff. They need to write something. They can write
silent. They are recording that.
Private lawyers have taken over all the It's supposed to be a lawyer, right?
My Lord, I'm only concerned with the statement. Private lawyer. Private lawyer. Are you officer?
So my Lord, one of the orders that was read is that these trials cease and be transferred. In there, they could have added, cease, the detainees remain in custody until the cases are transferred. They did not do so, and they were wise not to do so because they had just pronounced themselves on the illegality of the basis of those charges before the court martial. So my Lord, as we speak, there are no charges pending anywhere in Uganda or elsewhere, apart from a case in Buganda Road on which the first applicant is on bail. His bail is being extended, but he goes back to another location. That is the only one that is pending. But in that one, his liberty was given back to him. My Lord, the burden to justify the reason for detention, for curtailing personal liberty, is not on the one who is applying. My Lord, you can see that the affidavit was not even sworn by the one applying. The burden is not on the one applying. The burden is on the state.
And the state has
The state has replied. I'm going to address what it has said. There are two aspects involving the state, or two places where the state would have responded, in my view. One, the prisons officers would have brought before this court a warrant saying Court X on date Y told us to keep the body of these individuals until we go back. I have not seen it in the response. The second possibility would have been that they are pending charges, and this is the charge sheet. I know those pending charges can't come from the court martial. Because some of the offenses in the UPDF Act can't be tried in the civilian courts. There are offenses there that are very different, of a very different character, and they don't exist in the penal code. They can't be tried in these normal civilian courts. So they would have brought a charge which says, you in court X, they are pending charges. This is the reason why these people are in prison. What do they refer to? They refer to the Supreme Court decision, which did not say keep them in. So I want to submit, my Lord, and I hope that you will be persuaded that the response from the Attorney General falls short of justifying the reason for denying the applicants their personal liberty. Since the 31st of January 2025. It says nothing to you, my Lord, that explains why the liberty is curtailed. It only says the Supreme Court said transfer. But as I have shown you, some of these offenses, my Lord, cannot in fact be transferred. That may not be a matter for us to address here, but they can't be transferred. So it is our contention, my Lord, that a proper case has been made out by the applicants for this court, which is clothed with that power. But the power is unfettered. It is so unfettered it can be applied immediately. Clothed with the power to order the release of these applicants today. If the state has a lawful reason, let it act lawfully after those orders have been given to then deal with the issue, whatever the issue is. That, my Lord, my last friend has made reference to Section 15 of the Human Rights Enforcement Act. I am aware, my Lord, you are perfectly familiar with that space, and I very respectfully urge you, my Lord, to find merit in this application and to grant the orders that are being sought. My Lord, my land friend, Honorable Sekona, wants to just wrap it up.
How many minutes?
My Lord, I will request for only 2 minutes. Except that I request that the officer obstructing your view of my body language. You were told that you need to look at me. Yes. My Lord, just to sum up, Section 57, which has been cited by Madam Friend, is instructive. A prison's office can only detain on a valid warrant issued by a competent authority, in this case, court. Upon the demise of the General Court Martial, it is very clear that the power of the General Court Martial to order detention collapsed. And it collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent to this application. Whereas it is urged by the first respondent in the affidavit of Mr. George Kalemera, paragraph 9, that the Supreme Court did not order release. There was actually no necessity to order release.
So, yeah, on that point,
Yes, madam.
so you are trying to maintain some words in the decree.
No, madam.
Say it was not necessary, but it said so in so many words. You are thinking
I am not even wanting to go there. I am only restating the position of the Constitution. Under the Constitution, liberty is guaranteed. Restriction must be justified, and that justification must be a lawful one. And in this particular case, the lawfulness would only be cemented on an order, on a valid order of a court with competent jurisdiction. In the absence of it, there is no justification, and it is your power, my Lord, and duty to order freedom to reach them. Away from the Prisons Act, my Lord. My Lord? Yes, my Lord. Yes, my Lord, now is contextual. And what we are saying by now is that upon conclusion of our service,
Yes.
the court be pleased to begin writing the release order.
The release order.
In the same realm of context, my Lord, I now propose to take you to the context of the Supreme Court's order of transfer, which has been misconstrued. My Lord, this must be looked at from the perspective of Article 120 of the Constitution. The Supreme Court did not order the institutions to take over, because that is Article 1. In effect, the Supreme Court told the first respondent, if he's interested in any prosecution, go and start de novo. Start doing a fresh investigation, a fresh complaint. What one would expect is the state to report to the nearest police station
In Kenya.
and report and start with first information. Why? Because any warrant of court has an expiry date and tenure.
then I can ask for
My Lord, with your permission, and I'm grateful. Because the DPP cannot take over, the transfer order must be contextualized to mean, if you are interested, start a fresh complaint system. Go to the nearest police, report that these people are alleged to have committed offenses X. And when you do that, the DPP looks at the file, because the DPP even has the power to say, this one does not merit, and drop it at that stage. I was taking on the point that a warrant or detention order itself has a time limit. Bring back this person on this particular day. That is axiomatic. And the moment it expires, lawfulness ceases. In this particular case, the warrant of the defunct court martial was actually in itself expiring on the 3rd day of February. They could not extend or even terminate because they had ceased to exist. And since that time, the lawfulness, if at least it had not collapsed on the 31st day of January, died or redied on the 3rd. My Lord, to contextualize Act 120 and the decision of the Supreme Court, I would implore you, and we shall supply a copy, the decision of the East African Court of Appeal in Kagenyi versus Musiramo and another. Kagenyi versus Musiramo and another. 1968 East Africa, page 43. The gist is this: that a transfer is not even possible if the court originally had no jurisdiction. The decision of the Supreme Court, or even the Constitutional Court before, are to the effect that from the word go, the General Court Martial had no power, had no jurisdiction. So there was nothing to transfer. That's why I want you to contextualize the decision of the Supreme Court. Finally, my Lord, on the question you did ask me, when we say that you be pleased to order now, the word normally used by lawyers is extempore of judgment. Oh, actually, I'll come back to this. The word is, it is usually used to describe an oral judgment, including reasons for judgment, even at the time of the hearing. That is the context of we propose and implore you to find pleasure in ordering release now. But this particular case of Kagenyi versus Musiramo was cited with approval in Rose Wanjiku Jau. Rose Wanjiku Jau versus Nicholson Philip and 2 others. Miscellaneous criminal application number 387 of 2012 by the Supreme Court of Kenya. To sum up, in one sentence, the affidavit of Mr. George Kalibera, which attaches a letter purportedly by the principal judge. Now you can see the bad thing. exchanged without reference to us. Actually, those of us who went to the Supreme Court, does not place a lawful justification. It only talks about the administrative measures.
For the benefits of our media house.
Yes, sir.
Just give the essence, because you have mentioned the statement.
Yes, sir.
The essence of the honorable principal judge is that what is it in this statement?
My Lord, in principle, the honorable principal judge is communicating measures taken by the judicial administratively to guide the process of moving these files away from the deceased.
So let's bullet those measures. We can think about 3 measures in a bullet form.
No, my Lord. The principal judge, the honorable principal judge does not bullet those measures.
I'm talking about bulleting in our...
I'm avoiding the bulleting because I'll be reading it later, but I can read it. I have received right to the Minister of Defense and Veteran Affairs and to the Director of Public Prosecution. I have received the attached self-explanatory letter from the Honorable the Principal Judge, Justice, the Chief Justice, advising that files pending before the General Court Martial and that were subject of judgment of the Supreme Court and in the caption case be handed over to the Honorable Principal Judge of Parliament.
Bullet number 1, all files also.
Yes. This therefore is to bring,
Hold on.
yes, bring them to the Principal Judge. The next is, this is therefore to bring the advice to your attention for your appropriate coordinated action.
Request for coordinated second.
Yes. And it is a letter dated the 6th of February 2025. My Lord, even the principal judge's letter does not talk about the persons in custody. So it is not telling them to continue with the detention. In other words, there is no single order of a lawful authority to detain. And it is that order which would have been the justification to restrict somebody's freedom. Now let me ask a question and answer it. Thank you, Madam. That's the question. On whose order and under whose authority are the applicants in detention? Number 2, what is the criminal case number? The Supreme Court having said the prosecution ceases and with immediate effect by 31st. By fall night 31st, the criminal case number for the General Court Martial ceased. The file could be there for investigation purposes. You and I could be, maybe not you, maybe I could be under investigation purposes. Not for me, you should not, we need you. So the question is, under what criminal case number? And detained until when? The last time we had a detention which is unlimited in duration was under the Public Safety Act. And that one collapsed with the coming into force of our constitutional regime. Nobody can be detained indefinitely where there is no pending charge. That one will be the recipe for chaos in our country that anybody would detain. With that, my Lord, I can only say that let nobody drag the judiciary into this detention controversy of, say, relying on the order, the letter of the principal judge, an administrative letter.
But it's already dragged. I think
very unfortunate.
Ironically, we cannot run away from the bank dragging.
If we are going to go through this as authority, what letter of the PJ, the next thing they will request you for a letter of granting a warrant to retain. And this was not a judicial letter.
I understand.
It was an administrative guidance to those persons, if they are still interested in prosecuting. Anything beyond that, my Lord, is a persecution, and I would invite you to put a hold on it. I should prefer.
You know, the lady has been standing. I'm not really the lady's lawyer, but I'm dying to listen to the lady's.
My Lord, in a minute.
You are my classmate, I'm giving you my
Well, my Lord, in 1 minute, Sam is in the end of the name. I'll just take you to Article 43 of the Constitution, my Lord, where you cannot detain anyone without trial. There is no ongoing trial, my Lord. Secondly, everything about that general defunct general court martial was nullified. We cannot continue discussing putting something on nothing, my Lord. And an administrative letter, whether by the Chief Justice or Principal Judge, cannot be such authority to take away this provision of the Constitution, my Lord. My Lord, Father, my colleagues have submitted about Article 123, my Lord. If you look at 123B, my Lord, actually, my Lord, to conclude on the letter, to correct my statement. Our statement, when I look at this letter, it is by Chilewa Chiwanuka, not the PJ.
Actually, I apologize because I got a soft copy. I've only seen this physical copy. Now, with the correct, it is the Attorney General. I only got the soft copy here.
My Lord, to conclude, reading Article 123B, even the DPP, my Lord.
When you say the letter is by
Chiwanuka.
you mean the honorable affiliate.
Honorable, my Lord, honorable by designation, but I knew that this court will take judicial notice of that, my Lord. Finally, my Lord, my reading of Article 123B actually precludes the DPP from even taking up any matters from the court martial. It is very explicit. So most of the submission and the affidavit evidence that I've seen from the Attorney General is misconceived to the extent that it believes, the Attorney General believes someone can be in detention on orders of the Attorney General. My Lord, I join issues with my colleagues. Probably the rest will come in rejoinder. I'm obliged, my Lord.
Thank you very much. I think that's about all from the afternoon. Except I also wanted to express a little bit of concern. There has been a lot of story this court, particularly my friend. I mean, we love it when people express their mind, but you have to do it, not careless. Well, if I'm short, I die once and I be corrected, maybe you will not have gained anything. So probably your client's matter would have gone judgment, that's a old man. So, to your audience, tone it down. Fortunately, I don't take the line that if you insult me, then I will take you on in court. I love people to, they can insult me the way they want, but don't extend those insults. Threats. That, okay, that's about housekeeping. I got the point. Engine, can we listen? So, how do you reply to the application? So you listen to the comments of the arguments. Can you take us back point by point why you oppose the application?
My Lord, for record, then where I'm a senior state attorney. My Lord, your application for you ask for habeas corpus. And for habeas corpus has elements that you must prove for it to be granted. One is that the person for the applicant was arrested. The said applicant is in detention, whether by state or NPS, and that the detention is illegal. It's not in contention that the applicants were arrested and are in detention. The only issue is whether the detention is legal or illegal. And it is our contention that the detention is lawful. Your Lordship, we are not here to review the Supreme Court decision.
Let me go slow. I have to. So we are on the lawful. Point number one, bullet one is this court cannot review the Supreme Court decision.
Absolutely. And this is not the purpose of this. The Land Honorable Chief Justice wrote about 200 pages, elaborate judgment, and it is self-explanatory. And it's quite clear, my Lord, that any person who feels the application or the judgment of court cannot be construed in the way they feel it should, they apply the same court that issued it for clarification. My Lord, I'm not here to impose words, interpretations, because I'm not qualified to interpret the judgment of Supreme Court, otherwise expressly. Yes, and that's what I'll say. I'm not here to interpret otherwise as expressly given. Your Lordship, my boss, the Lord Mayor, is part of this building, has elaborately read through the orders of Supreme Court. And in any case, he would be on my side. He has elaborately read through the order of court, dot by dot, word by word, and nowhere did the court say release. It only gave an order of transfer. Transfer all the files which are pending before the court martial to court of civil courts. And from our affidavit, the bond by Mr. George Karimera, the Land Commissioner of Civil Justice, he has ably indicated your steps taken from 31st of January, when the judgment of the Supreme Court was granted. I will not go through all the steps taken, but I can only take the brief that on 31st January, the Supreme Court indeed gave that judgment. Most importantly, the court ordered that all charges, all ongoing criminal trials, all pending trials before the court martial involving civilians must cease and be transferred to the ordinary courts of law competent to fulfill and implement the order of court. On 3rd February, government commenced the implementation. We wrote to the Chief Justice, the Land Attorney General wrote to the Chief Justice requesting for a liaison contact on how transfer of files can be managed. On 4th February, the Chief Justice appointed the principal judge as the liaison contact and instructed him that all matters should be handled by himself.
So, if I now sit here trying to listen to this topic, I have superimposed myself on the role of the principal judge.
I'm coming to that. However, I didn't want it push it to your mouth.
No, you can't.
But since you have already said it, my lord, I take it, and that is the position of the respondent. And on 6th February, my lord, the Attorney General forwarded the Chief Justice's instructions to Minister of Defense and the Office of DPP. And on 13th February, that's when we received a decree from the Land Council for the Africans in the case of in the case of Attorney General versus Kawas. And on 17th, the same was signed by both sides. My lord, Article 28 refers to fair hearing and a speedy trial. Speedy trial and fair hearing is not one-sided. It is both parties. In this case, the applicants and the state. The state has taken action to implement the orders of court. The orders of court are clear, transfer the file. And it's not in contention that indeed the applicants had been charged at court martial and they had been remanded and there was a warrant for their remand. If the Supreme Court wanted to cancel the remand warrant, wouldn't have taken a paragraph after almost 200 pages to mention so. Only say transfer the file to ordinary court. And that's what the state is doing. It will be contempt of court, the Supreme Court. For this court, or the other way. And also, if Attorney General had not acted the way he has acted. the fact that the Supreme Court ordered transfer and did not nullify or order release all the accused in the court martial. And for your information, my lord, it's not the applicants alone who were for the court martial. There are many. The fact that there is no order on court record, and I have had my land senior police, Honorable Segona, trying to explain what is not exactly. I don't know whether we have different copies of the same judgment, but there is nowhere where the Chief Justice said otherwise, apart from transfer. And if we wanted so, we would do it. The fact that the Supreme Court did not say release, it was aware of what it was doing. And in that sort, it validated all the orders that all the suspects are based on guilt. If it had been otherwise, the sentence of saying release, actually that word alone, release, would have been enough. But if there is anybody that misconstrued the judgment of Supreme Court, the right forum is the Supreme Court. As an office of this court, and it's guided that do not be misguided by my land colleagues from the other party. Most of that. Most of that. And I'm alive to the fact that you are the doctor, you know.
Let's not go there.
There are good parties in this. What is meant by saying this? It is in the interest of the state and for the people of the country that justice is done on both fronts. The biggest issue.
What the lawyer said and said, fine, you are doing something. For how long must this will take? And they want to take it.
Yes, my lord. I will not accuse the Supreme Court of taking of time. But however, from the reading of our evidence, the judgment was given on 31st January. Immediately, on Monday next week, which was Friday, we acted, and the process is ongoing. We are not going, I cannot mention how many files are involved, but they are numerous. And the process of expediting the process is of course, and that's why the principal judge was allocated this responsibility. It would be premature and alone.
There is an allegation of fraud speed on your part. It is because of the volume of work you have handled and not that you have anybody to say.
And it would be justice, my lord, to say that slow speed. For example, this application was submitted last evening around 9 p.m. There is an after report. I didn't sleep. My team did not sleep. That the general did not sleep. I was on the phone after meeting to respond, to ensure that justice is served on both fronts. My lord, in conclusion on my part, this application is concealed because the applicants are aware that they are in invitation legally, and the state is not denying where they are. And at any time you want to look like him, you can even visit him, anyone can visit him. And if anyone wants him to be produced in court, can be produced in court. But ordering his release would be the content of the Supreme Court. So,
I would like to associate myself with my colleague's submission. And I just want to emphasize that as has been rightly submitted by my former teacher, my Lord, Pastor Kalibala, that yes, one of the orders, one of the conditions has been fulfilled, and that is the production of the applicant. Now, the other issue would be the lawfulness for whether or not illegal or legal detention. My Lord, I want to emphasize that we should not read into the judgment of the Supreme Court what it did not provide. This was a decision of the Supreme Court, not sitting as an ordinary court, but as a constitutional court. And my Lord, as the highest court of the land. Now, my Lord, as officers of the court, we need to respect court orders. And for the applicant to come to this court and read into the court's decision that the warrants that were given by the court-martial have been invalidated is a very serious misconception. Our submission, my Lord, is that the applicants are in lawful custody. And why am I saying that? I would like to make reliance on an authority of our Bassett governor of Brixton Prison.
Instead of going there, why don't you discuss it in the former teacher said he did while where he was no. But the court went ahead and said,
in fact, my Lord, I am trying to justify that we are holding him or holding the applicant in a lawful way, or we are having them in lawful custody, supporting what my teacher said, that we should justify that we are holding him in lawful custody. And in this decision, my Lord, called our Bassett governor, Brixton Prison, Besigye, my Lord, the House of Lords was examining whether a detainee held under extradition proceedings would be released via habeas corpus, despite procedural irregularities. The court held that even where there are procedural errors, detention remains lawful if there exists a valid substantive basis for the person's confinement. The emphasis, my Lord, is if there exists a valid substantive basis for the person's confinement. My Lord, this is the valid.
you have not decided.
Yes, my Lord, that's right. Now, my Lord, in this case, Dr. Peter Besigye and the applicant here were arrested and charged with various criminal offenses, including prison, which justifies their pre-trial detention under Ugandan law. The fact that this case was initially handled by the court-martial does not negate or does not invalidate that we had valid reasons, my Lord, to detain them. And my Lord, the Supreme Court, well aware of this, simply said, transfer before court. Our submission, my Lord, is any argument about the warrant being not valid can only be made after the process of transfer has been completed. And this will happen before the criminal court, which is going to handle his matter. My Lord, it is very misconceiving and misleading for this court handling the matter of habeas corpus to go into questioning the validity of the warrant, which is the basis for which the applicants are saying we are holding him illegally. My Lord, that is not the purpose of habeas corpus. We are praying, my Lord, that you be persuaded by this decision. And my Lord, you have highlighted the relevant facts, and you will notice that the court said, the court actually said that you should not question. That the question then arises, what should be the proper approach by the court in determining any such inquiry? Of course, the authority on which the lower court applicant is the authority of the court. The court martial of the court can only, and it is still the court, can only be to see whether the court, this is what is court says, can only be to see whether the court had facts before them, entitling them to issue the authority, the warrant. This is what we are telling you, my Lord, that we had valid reasons to retain the applicant. But to have you right now that the warrant is invalid is not proper for you, my Lord.
Wind up.
And on that basis, my Lord, we pray that this application is missed for being premature. We have clearly stated to you through the affidavit of Judge Calendar the processes that the Attorney General has taken in compliance with the orders of the Supreme Court, not outside the orders of the Supreme Court. My Lord, we pray that you have persuaded by our submission that this is the application.
Minutes. At least we know the company, we know the argument.
Yes, my Lord.
What we already know. So you can highlight maybe in 3 minutes what
In 5 minutes I will be done, my Lord. Most of luck, my Lord, on the contention that the applicants are in lawful custody. My Lord, we are really disturbed by the justification given by the senior state attorney here, reading too much into the Supreme Court decision. Is suggesting that by ordering a transfer of the file, by extension the remand warrant was extended. That is, if I got him well, correct. That is an absurdity. You reached the point of suggesting that if court held otherwise, it would amount to contempt. If this honorable court held otherwise, that it would amount to contempt of court. We take exception to that, my Lord, on the following grounds. One, my Lord, the Supreme Court was categorical in its direction. And if they wish in any way to save any order of the defunct General Court Martial, they should have said so. If in any way they deemed it necessary to keep the applicants on remand pending transfer of their files, they should have expressly stated so. It's nowhere stated in the order. My Lord, the Supreme Court went ahead to give structural interdicts in regards to areas of amendment to guide Parliament. If they would go out of their way to guide the Parliament, if they have come up with a new legislation, the parameters, the principles, how about on the issue of remand, if indeed they want the applicants to remain on remand pending the transfer? That is one too.
No, before you do that.
Yes.
I understand this structure. The court will say you have to do ABCD within 6 months or 1 year. If you don't do it within that time, we shall do it like for you. And the wording shall be like ABCD. That is how I understand this structure. Is what the Supreme Court saying.
No, that is for the legislative process. There was structural interdicts. But for declarations, my Lord, they have to be contextualized within the existing constitutional order. Now, for the transfer of charges and files, they have to be put within the context of Article 24, rather Article 23 of the Constitution. And I will read Article 23. Article 23 4B, the 48-hour rule. That anybody whose rights are whose liberty is restrained shall, if not earlier released, be brought to court as soon as possible, but in any case, not later than 48 hours from the time of his arrest. My Lord, the Supreme Court decision should be read in that context. That actually the Supreme Court did not purport to overthrow the Constitution. They couldn't do so. So if the state wished to continue with the prosecution of those cases that hitherto were being handled by the General Court Martial, the time frame is set by the Constitution, 48 hours. And in lawful custody, I don't want to give them their advisory, but if I were to go there, what I would do immediately, you would get them from prison within the 48 hours, take them to police, in police custody, because you would be then be breaching section 37 of the Prisons Act to keep them on remand without a remand warrant. If I may ask my Lord, is the prosecution, I mean the state attorney is justifying the detention?
I ask the court so
The
that
court.
we give you the answer.
Okay, let me give the answer here, my Lord.
No, it is okay. You can ask and you frame it as a question.
Okay, let me frame it as a question, my Lord. Are the applicants right now on remand? Are they on remand? Pending what charges? If they are in custody, pending fresh charges being preferred against them.
You have asked for questions right now.
Right now.
If so, what charges are they facing? So you continue so that
Yes, what charges are they facing if they are on remand? And if I may add another question to that. If indeed they are awaiting transfer of their cases or charges for that matter. In the affidavit here, they are indicating those charges, those matters are being handled by the DPP. And my learned colleagues here have cited Article 120 of the Constitution, which bars the DPP from sanctioning files before the General Court Martial. Has the DPP got anything to do with those charges, which were either being handled by the General Court Martial in the context of Article 100? Even if they were to be transferred, has the DPP got anything? And finally, still on that question, my Lord, when you read the affidavit of Karemera, the Attorney General simply says that he wrote a letter to the DPP and the Minister of Defense. He is not indicating any action taken. Yes. Most obliged, my Lord. Does it in any way address that? And in any case, my Lord, in section 10, the Attorney General's Chamber forwarded the Chief Justice letter to the Minister of Defense and the DPP advising that the files be forwarded to the Principal Judge. The Attorney General simply states that they acted as a conveyor belt. They received the letter from the Principal Judge. What did he I wanted to advance that because this is my construction of my understanding. I wanted to make one announcement. Yes, because within the meaning of Act 100, the office of the DPP is independent of government. Article 100. And I want to conclude it by indicating to you there is nothing on record that shows that the DPP has taken any action. There is nothing. There is no record whatsoever that the DPP has taken any action under Act 100. In reality, that is one. Two, yes. My Lord, the DPP had 48 hours within which to do that. Yes. My Lord, the application for habeas corpus is now being had and it is not charged by the DPP. And this is our position. With all due respect, my Lord, I wouldn't want to mention the matter which is now instructed, my Lord. Related to that, there's nothing on record here regarding any action being taken by the Minister of Defense. Let's go to paragraph 10, that the conveyor belt, that is the Attorney General, after relaying the communication from the Chief Justice. Because the Justice Chambers forwarded the Chief Justice Center, the Minister of Defense, and the CPP. As a courier, now not a compare page.
Except now the son doing it on behalf of the father was
So, my lords, after laying this message, this communication, transmitting, actually, transmitting the communication from the after the transmission of that, no evidence show that action was taken. And they have the honorable court. The process is ongoing. And they are saying they are overwhelmed by work. This is the point I wanted. What work are they overwhelmed by? Because they are supposed to transmit the letter to the Minister of Defense and as a so what work is what is because they are not involved in the process. They are
the team is fighting the white squad.
So what is
it's serious and even run the NRM in the last it's not been made a judge.
Whatever they needed to do in as far as transfer of charges, if anything, should have been reported. No, if they wanted to put that in any action being taken.
I could judge. Yeah, some point to the panelist. The table for NRA money. Supporting abduction,
the demand warrant had to be saved by the website. And if at all it had been saved, like they have argued, it lapsed. My friend here, Segon and others submitted extensive from that. It lapsed on the 3rd of August. Rather, sorry. It expired on the 3rd of February. And to date, my Lord, it cannot just be yes, it can't be resurrected. And the reason, and these reasons authorities who are here, they normally move with the document for extension. Do they have one? That we have it here, which can be extended. They don't have any. And this honorable court, my Lord, cannot give them any remand warrant. I beg to submit.
My Lord, if I may.
I came here to make directions for Detention. So I was cornered by the Lord there and I abandoned that. And for good reason. So let's now.
My Lord, I'll try to do it in maybe 10.
10 is too much.
At the max, I will try to.
5 minutes.
And my Lord, they are again just 2 points. The first one, I would like to just draw the court's attention to. It's about the burden of proof. And specifically, there are two sections, 103 and 106 of the Evidence Act that are important for the court to consider. The first one, 103, says that the burden of proof as to any particular fact lies on the person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. So, in law, sometimes burdens are placed on particular people, but that's a general principle. 106 is more specific. In civil proceedings, when any fact is especially within the knowledge of any person, the burden of proving that fact is upon that person. And that person, in this case, my lord, is the respondent or the respondent. The particular fact is the lawfulness of curtailing the liberty of this applicant. The respondents have pointed to the three ingredients. They said two are satisfied: the arrest of the applicant, the detention of the applicant. The third we are addressing is the lawfulness. And so the evidence of the lawfulness is critical, and there is no evidence of that lawfulness. What we have been treated to in this affidavit is a reference to a process that was stopped at the stroke of a pen. That process ended. It stopped. It cannot be resurrected. That file cannot be restarted. It is non-existent. But that is a file that is being referred to as the basis upon which these two applicants are on remand. The second thing that the state has said is that we read the judgment, we are complying. And they have attached some documentation to suggest there is a process that is being undertaken. My Lord, for my part, I will be grateful that indeed they are saying something is being done. The question is whether that thing which is being done means that the detention is lawful. No, it isn't.
Let's stop for a while.
Yes.
Mr. Kaledera came here to say we have done that.
Yes.
Your argument is the same.
My Lord, to me, the argument is exactly the same. The compliance, the issue we are dealing with of personal liberty, cannot be justified by administrative processes which have no time limit, which we do not know the details of. They can do those things while these people are enjoying their liberty. Because they can't demonstrate that they are being loved. So if it takes a month, or 6, or 2, or whatever it takes, we are grateful that they are saying something. It's good. But it doesn't answer the question of whether this custody is lawful. Now, my learned friend suggested that the applicants are lawful custody. The only thing I can say is that they are in a place that is lawfully gazetted to keep guests of the state as in sometimes. But yes.
What you said, even when there are some problems, you cannot succeed easily under arrest. That's what you have.
My Lord, I differ.
Yes. Now I want you to differ.
First of all, the facts that we are dealing with, I think, are different from the basis on which this decision was made. Under our law, what the respondent, and there are two of them here. The first one is the Attorney General, who may not have direct engagement. but it is extra. The second one has actual knowledge because they are keeping the Commissioner General has said nothing in response to this application. And I'm not talking about the person of the Commissioner General, but prisons has said absolutely.
So this brought the people. So he has not done that.
They have said nothing about the lawfulness of the detention. My Lord, it's important that we focus on the lawfulness because the lawfulness, in my opinion, comes out of three things, which they could have demonstrated if indeed they existed, but they can't demonstrate it because those things don't exist. Is there a charge anywhere which says they've been charged, they've been remanded? No, there isn't. Is there a warrant that remands them beyond the 3rd of February 2025? No, there isn't. That's why it hasn't been brought here. Is there any order of any court? That's the third point. Any court anywhere, even if it was an else court, that says remand. My Lord, there isn't. So when we go back to the burden of proof, that fact, that is especially within the knowledge of the respondents, the reason why these people are passport has not been brought. You have been treated to the argument that we are doing the best we can. The best they can be done when these applicants are enjoying their liberty. That is what we have here focus application. About. The moment they can't demonstrate this fact, especially if they are not, my Lord, we pray that you be persuaded by that the third point of which we agree with my last friend as important has not been given by the respondent. The affidavit is here, my Lord, you read it. There are averments with no attachments, saying something but nothing is demonstrated. Saying something but nothing is demonstrated. This matter would have been very easily dealt with if there was a court order, the remand warrant, or a charge. Simple as that. We wouldn't have said much. We would have just looked at it and said, oh my God, this is it. Okay, we understand. If it isn't there, my Lord, I implore you, let the Constitution prevail. The Constitution must prevail over every circumstance. Unless we have reached a point where we are saying it has no meaning. And I'm asking, my Lord, respectfully, I'm asking respectfully that this court, yes, I'm addressing it directly.
The fact that we are here suggests that this court is mistaken.
My Lord, I agree that we do respect it. I am asking humbly, respectfully, that in Article 23 we allow personal liberty is something which cannot be compared with anything else. Being incarcerated for lawful reason is terrifying enough. Being incarcerated for no reason at all has no place at all under this Constitution, unless we apply it, and we are not. So, my Lord, I rest that I respectfully urge the court to find our submissions in support of this application, convincing, satisfying, persuading enough for you to grant the order. That order, as my Lord said, can be granted extent order. Circumstances do sometimes face that. But that, my Lord, will leave. That will leave the court. I thank you, my Lord.
Yes,
How many minutes?
one, just one. The senior state attorney, apologetically, whose name I've forgotten, that will did submit about the decree which was sent to them on 17th of February, suggesting that they got it late. That one is very surprising because the applicants were not party to the Supreme Court. We are not here to enforce the Supreme Court decision. We are here, my Lord, to enforce the Constitution, which guarantees the liberty, whose restriction has not been justified. I think the only problem with the respondents is reading the Supreme Court decision in isolation of the Constitution, but also reading it mechanically. Mechanically, that they were waiting for a decision to set release.
Simplify what you mean. So that's our journalist
Well, my Lord, with your guidance, I will, although my primary concern is you.
But they consume and they help us
Sure.
share this information because then manages detention.
Thank you, my Lord. And I will do that.
Mechanically.
Mechanically.
Without thinking, like a robot.
I refrain from saying they are not thinking from here. I want to say they are thinking, but mischievously. Mischievously because the foundation of the court decision is giving effect to the liberties guaranteed under our Constitution and not restrict them. So the way the Attorney General is interpreting this Constitution is mechanical in a sense that he uses it to achieve a particular end. And that particular end is to continue the detention. My Lord, Section 57 requires a detention order to be signed and sealed by a person authorized by law. So the question is, whose signature and seal exist on the detention order, if any? Which is, if it exists, it has been hidden from court. And that is intended to deny the applicants the protection of both the Constitution and court. My Lord, if someone is indefinitely held in custody, when do you come in to protect that person? As court. As court, you issue a warrant with limited timelines to ensure that this person is properly protected and is in good order. But what the Attorney General is preaching us on today is to say, for as long as we are undertaking these administrative processes, it's okay. A violation is not acceptable in our constitutional framework, not even for a microsecond. Hello? But we are not even bothered about how long it takes the DPP, if she intervenes, or even the transfer process. We don't care. The DPP might even decide not to touch this file and say that file is a nullity ab initio. I will not touch it. In that case, you keep the applicants in prison forever. My answer is that this sound and trusted court will not say yes. About the last one, on 2. My lucky friend, Miss Amusut, did say that by necessary implication, the Supreme Court validated, actually she used the word validated pre-existing warrants. No. The Supreme Court said the trial is a nullity. And which lawyer doesn't know that a nullity is a nullity? The Supreme Court knows, like you and I know, that a nullity is a nullity. It cannot be the foundation of any lawful action. Therefore, no amount of validation can resuscitate that demand and this action. With respect to the case she cited of Arabas, governor of Brixton, especially his party now, I have read it. I think I read it before, but I can refresh. Specific reference was made to a lower court. There is no lower court. Because at the time it was done, it was valid. This case is distinguished. It has never been valid. The decision of the Supreme Court, and I find solace in the fortification of the decision cited by 67 cases. If it is a nullity, nothing can be founded on that action. And besides, even assuming that it was a valid warrant when it expired, under what case number, in which court are these people being held? There is none. The word is a remand order, and that is the cornerstone of legality. It does not exist, and it cannot exist because there is no case pending. You cannot issue an order. You cannot issue an order at a non-existing case. And you go and be detained for the next 1 hour. No. Finally, my lord, you must not leave this kind of liberty to the detainer. The Constitution did not intend and did not give it. And who is currently the detainer? Currently, the detainer is the landed Attorney General, Honorable Chirewachiwanuka, the Attorney General, because he's the one telling these people you can continue to detain. The detainer can only be court in a matter properly placed before court. The emphasis by my learned friend Amusu that we have a justification and therefore so to get solace in the decision of R versus Governor Supra by saying once they have what she called a substantive basis, is a recipe for disaster. That once the state thinks they have a substantive basis, they can detain you forever. My lord, even if the Attorney General said they are concluding this process today or even tomorrow, the detention remains illegal. It has been brought to your attention, my lord. No excuse of administrative process can permit any further detention. I think they have even sought to intimidate you by saying the order you give might amount to contempt of court.
No, if it is about intimidation,
yes.
from your mouth. For the media,
my lord,
it's been coming to my inbox. Yes.
For the record, my lord, my camp is this court. My client is in prison. Unless you receive that message from his wife.
What message says my days are numbered? You don't see the light of tomorrow.
I want to bring that catch in Jesus' name. At least that you do not leave before you give us this body. But on my part, my lord, I can only say we have no camp. I represent them.
I will
Most appreciated. Most appreciated, my lord. I'm only saying, as Amos said, that if you give a decision as prayer, it will amount to contempt of the Supreme Court. The Supreme Court has never made a decision of continued detention. If anything, like you did right earlier, the Supreme Court restated and protected the Constitution. That one is your solemn duty to protect the Constitution. We should come here equal before you and before the law. Here we are coming with a recalcitrant detainer saying, as long as I have no decision, the Supreme Court to say release, I will detain.
That one is a difficult thing. Can you split it down? I'm doing it deliberately so that if the phone is a bad one, we are bad.
Of course, I must apologize, but with this age, by the time I went to school, we were learning difficult words in the eyes of some, ears of some other people. But I must say, you have a non-compliant and delinquent detainee who does not want to listen to the law, the command of the law. That's why I'm saying that this is a person who is maybe outside the courtroom would call it. I use a smaller one.
What you are going to say outside is
okay. In court, my lord, it is primitive arrogance for a detainer to say, I will not release until I have an order. Thank you, my lord.
My lord, 1 minute enough. I'll start from where my colleague stopped. We've dwelled so much on the administrative issues of the delinquent detainer. And my submission is that nothing done was supposedly done by the Attorney General, not even the DPP, constitutes justification for the applicant's detention. But for brevity, in as far as the misconduct
But what's the problem?
Fine.
by validity. Then the lawyers have the joint warrant. So it's like once
Yeah, my data was over. Data yabadde aweddeko. That's why I went off. Data yabadde aweddeko. Katukomyewo.
yeah.
By way of prejudicial to the applicants in that at times, my lord, we go out of the outside the briefings when you are interrogating matters to my lord, it is allowed with issues to do with the because it's an interrogation matter. No, my lord, what I'm saying here, once when someone is authoritative, detaining the applicant, please bring this person here. Court has to pose questions. All questions emerging, they come like it has happened to them, my lord. So if it is by way of written submissions, my lord, there are issues that will not be canvassed, and that is my concern. Yes.
I have one deep direction for 30 minutes and I but I detected I would be misunderstood. So I allowed let's go back to what I had planned before. Number one, all the pleadings should be served to the open council by clause of the reply should be in. All the parties should write as many words as they want. I'm not going to leave it. I normally leave it by end of business tomorrow. So that gives me time. We are not going to stay. I will start drafting the decision today.
What I was raising here, I'm sorry to keep insisting. Like we are earlier on saying that it's from the matter when we talk about what just happened. First produce the body, and the body is here. Now the question is interrogating why that body is then something. That's difficult, my lord. With written submission, arguments and counter arguments.
I am lucky I have two teachers here. And they will look at me when I understand what they want. If I come to think that it's not possible, they don't need to know that it's possible.
You interrogate in writing.
Yes, they told me. Thank you very much. Now,
And then the consolidation, my lord.
because it was consolidation, because I picked it up, in your argument you can say that it's a wrong consolidation. Someone can say a decision to be made on consolidation. I was just throwing an idea. So thank you very much. That was it.
The submissions are for
Yes.
I'm looking at
for the motion you have. Now, if you look at the motion,
video sana ikikaa nange biganye tebagenda abata biganye
that case challenging the appointment of minister since it was filed now. It's challenging the appointment of PDF officer.
Facebook kuterekayo live ate Facebook erekayo live kubigenda okubanga bigenda mu maaso wabweru waawo ngenda kubeera live ku Facebook ya Sama Uganda Media tulina ne YouTube channel bagiyita Sama Uganda Media.
Banange ebintu biwedde naye tebasazeewo, they have not decided tabawadde lunaku lwe bagenda kukomawo naye nga biwedde nga teri kibadde kigenze mu maaso yadde
Você
banange baganye okutta Besigye. Kati olutu tuba tutandise tetumanyi kiri wabweru naye kyetutegeddeko nti kunuupu badiployinzeewo amagye. Baba embeera bwetyo bweri muganda wange ali ku extreme media YouTube, subscribinga, likinga ate era commentinga. Bwe kyolina okumanya nti ebintu bikalubye, Besigye baganye okumuta. Sheyalinga embeera kazigizigi neeno. Baba oyinza ogamba basimbulidde wano. Ero nikizawe bamuzaya tugenda kavule kati kweni UP nawe bagambye Excuse me. All right. The situation here. Yonna kyolina omanya ejjudde bantu tugenda ku kitebe tulabe kino ekiddako.
Ebifiti byabwe tubireke biyinza
alright banange subscribinga nakyolina omanya tetugenda kuvaako kuneeno oli ku extreme media yuge gambye alright mbeera buti tugenda ku kitebe kati wetwogerera oli egulupu y'abantu bangi nnyo kyekiddako ngambe tugenda
Impulira. Simanyi. Just come back to him. Ana mkatole nyema.
Are we set?
with due respect to the trial judge, we do leave the court premises today with disillusionment in the way the matter has been handled. We are really disillusioned with the way the warrant has been processed, because the writ of habeas corpus, which in simple terms is a prerogative order which can only be given by court in exceptional circumstances like this, where one's liberty has been curtailed without any justifiable or lawful cause. It's a matter which has to be disposed of expeditiously. And when you look at the provisions of Article 23, read together with Article 44, this right to a habeas corpus is non-derogable. It comes into play in emergency situations like this, where one's liberty is curtailed and their life is in danger. So Dr. Besigye was brought together with Obed Mutale this morning under very, unreasonable circumstances. There was an order that he be returned to Muzira without a valid remand warrant. Yes, we appreciate that the court ought to have listened to all of us, both sides, before rendering a decision. But we made a good case for quick intervention, and we thought the court would come up with the declaratory orders today about the legality of the doctor's incarceration or the curtailment of his liberty. Unfortunately, it has not happened. Yes, we have made our submissions. We are grateful that the judge has listened to us, and we also appreciate the fact that he interrogated the circumstances under which Dr. Besigye and other prisoners of conscience have been detained in total violation of the Supreme Court order or directive. Unfortunately, we have not got a decision today. We are walking away from the court premises without a remedy today. So we expected a decision to be delivered today. It should be instant. And we brought out all the relevant authorities. That would require that, honestly speaking, the justice of the case required that today there should be a remedy, there should be a decision, and it should be instant. Unfortunately, that is not the case. And to make matters worse, we have not been given any idea or clue as to when the decision will be given. We have been directed that tomorrow we write to the judge requesting for the date when the decision will be delivered. It's really baffling, because at least if he was not in position to give the judgment today, probably would have indicated that give me today or tomorrow, then I will deliver the ruling within the course of tomorrow or the day after tomorrow. That was never to be the case. You see, you cannot again curtail one's liberty, which are duly guaranteed under the Constitution, the Bill of Rights, on account of the government-related bureaucracy. You had their flimsy arguments. The state, the Attorney General, they are saying they are exchanging the communications, a letter to the principal judge, a letter to the Chief Justice, a letter to the CBF, a letter to the Attorney General, a letter to the DPP. They are just still exchanging the communication. They are hiding under red tape, under bureaucracy, to continue violating the rights of Dr. Besigye and other prisoners of conscience. We thought the court would bring that to a halt, that would stop that kind of impunity. Unfortunately, it would appear court developed think of delay and had to delay the delivery of the judgment. So we are going to retreat and see the next course of action, how we shall get the remedy under the circumstances, as we await for the court decision in this matter. But we leave this premises with a heavy heart, with the disillusionment, and of course devastation. That is it.
Honorable, the most concerning thing has been Dr.
I've canvassed all that because you have really stated the fact that Dr. Besigye is deteriorating by the day. And the judge ought to have recognized that fact, and it should be a compelling reason for the court to deliver the judgment today, to determine the fate of Dr. Besigye today. And we thought that would be instant, given the deteriorating health situation of Dr. Besigye. So we thought that would be a significant matter that would compel the trial judge to render a decision today. So I think that is what we have covered sufficiently. So kakati tubadde mu kooti naye tugenda nevuunya ku mutima nti tubadde tusuubira olwaleero application eno ejja kulira okusooka mujjukira abantu bagifukisinze nga 25 omulamuzi n'atubeerera wakisa n'akyusa n'agamba gaa mujja olwaleero era nekituwa essuubi bwe tujja olwaleero bw'anaamala okuwuliriza tufune decision ey'amangu twenyamiza tuleetedde funya mutima yadde omulamuzi tumuwa ekitiibwa era tusuubira nti kale agenda kukola omulimu gwe asalewo naye ayinza okusalawo ng'embeera ndala omulabye obulamu Dr. Besigye bwalimu n'omulamuzi yennyini abulabye n'okutuusa kati tannafuna mbeera efuna bujjanjabi bumala obutuufu okuva mu badokita yebe yekyuzingidde ate n'okuva mu ddwaliro erina obusobozi okukola ku bulamu ate nga twalaze nti okuva nga 31 omwezi ogwa January tewali bano kye baali bakoze era olwaleero kyeyoleserwatu nebyo boogera ebya transferred files bagenda zitwala mu civilian courts tebiriiyo kyeraze lwatu kubanga mu affidavit ereeteddwa state attorney bwe bujulizi bwabwe balaga amabaluwa ge beewandiikira nti attorney general yawandiikira chief justice n'awandiikira principal judge the principal judge n'awandiika ebbaluwa ng'edda bwe ya attorney general mu attorney general bwe yagifuna n'agiwa CDF n'attorney general era endala n'agiwa DPP nga bagamba nti kale mukole ku process ey'okutransfaringa files temuliimu nakawaayo nakamu mu affidavit yaabwe we bagambira nti files zino tugenda zitransfaringa era ku lunaku bwe luti ate nga ssemateeka alambika bulungi tojja kutumira muntu mukomera okugjako ng'olina ebiragiro bya kooti ekyo tuzze tukinyonyola internet mandi warrant yaggwako tebalina court order mpya tebalina kiragiro kya kooti yonna tebaguddeewo misango mipya kakati bakozesa kyebayita impunity of the highest order kyekyo ekituleetedde okwennyamira mu mutima omulamuzi atugambye tumuwandiikire olunaku olw'enkya tumusabe nirwanatuwa ensala ye ero kyennyamiza naye katugende tulabe ekyokukola oba tumuwandiikira naye kitunyize nti olwaliro tufunye ensala ku nsonga eyo kubanga kisigadde mu bbanga bwekiti era bali baddeyo bakole ebintu byabwe by'ekifandulo nga babadde bakola naye tugenda kutula butuuzi katuddeyo kwatagane n'abakulembeze bonnanga balaba wano tulabe ekyokukola kiri mu mateeka ne musobozebwa ngebalemu ne bali
Thank you. All has been spoken by our brother, Council Kwabo. One thing that I want to put in black and white, this is not prosecution, this is persecution. Dr. Besigye would not be brought to court today if it was not pressure. You notice this is the same judge that sent Kabwenza to prison instead of sending him to the ICU after the work reparation. This is the same judge that said the cash bonanza parliament was big. At the same time, this is the same judge that is sending Dr. Besigye back to prison instead of sending him to hospital. This is the Kanda judge. This is the regime persecuting Dr. Besigye and all other political prisoners in the name of prosecution. My only call is to the people of Uganda here and abroad. The only thing that works in this regime is pressure. I want to thank all those in Kenya, in all of East Africa and all over the world that are putting up pressure. Please put up pressure. From here, we are going to hold prayers at Catholic for Dr. Besigye and other political prisoners. we are not going to stop. We gave the regime 48 hours to release Dr. Kizza Besigye because we want him alive. They are trying to kill him, and all of you see. So I call upon the nation, all people who will to stand with not only Dr. Kizza Besigye, but all political prisoners, especially those that are in prison illegally, courtesy of now the defunct military court. So stand with Dr. Kizza Besigye and all political prisoners, exert pressure, because pressure is the only thing that works under the regime. Thank you very much. Ebisinga kansuli kwagalyogedde ekyenjagala okwogera mu bulambu kuno sikozesa wabula kutulugunya bali mu kutulugunya Dr. Besigye n'abasibe bonna abaasibwa mu bumenyi bw'amateeka. Singa teyabadde pressure wano mu Uganda n'okwetoola eggwanga n'okwetoola Africa, Dr. Besigye teyandise kkooti olwaleero kuba tebamwagalanga mulamu. Ensonga lwaki bamutadde mu kukomera mu mbeera gy'alimu. Njagala mujjukire nti omulamuzi oyo y'omusindiza yasindika Kakwenza Abasajja kukomera mu kifo ky'omusindika mu ICU ng'ali bulungi. Ye mulamuzi y'omu eyagamba nti enguzi y'omu paliamenti yali mu mateeka. Service award yali mu mateeka. That's the same judge that said the service award was legal. Kati ye mulamuzi y'omu yasindise Dr. Besigye mu kukomera mu kifo ky'omusindika mu ddwaliro. So kuno sikwozesa Dr. Besigye oba abasibe abalala wabula kubatulugunya. Nti bagambyeko nti teyandize olwaleero singa teyabadde pressure gye mwataddewo. N'olw'ensonga eyo nze njagala okubasaba mwenna gye muli muteekewo pressure, twebaza mwenna abeekalakasiza okwetoola East Africa ne wano mu Uganda. Temulekerawo kuba bano bawulira pressure yokka, abatulugunya bawulira pressure. Okuba wano naffe n'abakulembeze abalala tugenda kuba n'okusaba kakule katusabira Dr. Besigye n'abasibe bonna abali mu kkomera mu bumenyi bw'amateeka. Ne nammwe tubasaba buli omu bw'ali mu ngeri yonna gy'asobola ateekewo pressure. Social media, street n'awalala wonna kubanga bano bawulira pressure. Mwebale nnyo.
Kale ekiriwo Dr. Kizza Besigye bamuzizaayo era baganye okuba olunaku ne balina okomawo waneeno mu kooti. Kati okusinziira ku President w'ekibiina kya National Unity Platform President Robert Kyagulanyi Ssentamu agambye nti kiva wano tugenda ku kavule era agenda kusaba bagenda kubanga basabira omuti basabira bebasiba. So embeera bweti bweri waneeno tukyali ku kooti waneeno tukyali ku high court. We are eagerly waiting to get a fix. Military jeeri naye munnange banaatugaana ogenda banaagaana ab'omu maka gaabwe. Military jeeri basazeeko naye era tulina okujja kiringa gwe kuba nti bakusitopinze okugenda ewakaawo. So embeera bweti bwolika naye nga poliisi yo
Poliisi yo tulindidde wabweru wane n'abantu bangi. Poliisi yo tulindidde.
Teyogera bya kisimu.
Abapoliisi boda yatukole banange embeera bweti bweri embeera bweti bweri embeera bweti bweri kale tugenda wa tugende kavuli anani foka sija tugende boda yatukole owaboda anayimirirawo yatukole jangu kavule kunu meka
zibanya
tugende yangu wako ensawo eno mutuleko lye yekibaji nawe tugende alright banange tugenda kavule boda tekamuko ka speed ye
so kina abana
speed yake abana ani atalina abaana ate gwe ina batono naye gwe bakimanyi nkusinga abaana Tata nsirise nasirise tugenda kavule kyofasemu yakaingeza tugenda kavule atuli mu maaso naye nategeddemu nti ekiro ogezeke kavule
iyo bebayita abajjaji
bweri abajjaati ekavule
bebasazeeko abajjaji
tugenda kavule ono abaddeyo mu kooti bannange buliwo oyita majje antuli ku bitaala ebyemulagulawo teekawo leyi mbeera bweti eri muganda wange tugenda kavule
era naye alikuja kavule
aye kati ajja kukola ki ekavule okategedde oyo ye BM focus naye tuliwo yasitudde nange Uganda bwetu bweri bwetwogerera kati nga bwoli mukulaba tugenda kavule taata tulabe nayo kyekigenda mu maaso tulina obatuusaako ekimu ekigenda mu maaso mu ggwanga naye nga webale kubanga oli ku Extreme Media UG subscribing if it's your first time here Besigye ali ku Extreme Media UG president owuli eri gyali yasazeeko dda subscribing Besigye mwena mulaikinga video abagiriko mwenna tugenda kavule tugenda wa kavule president wuyo tugenda nnyo tugenda kavule kyakyo yajana nzima gini ekola ki kukitebe adnage nga fe tuyingide naye nga sikiwa nti tujja kuyingira nange tuli mukumbe kutuuka embale mugamba mutya babaano oyinza ogamba waliwo malakisi kale tutuuse ku kitebe naye ndabawo ebyokwerinda nga bingi
bajja ati tebaga kamera demu
basasula
ani nze ndikwayo 10
akodi yangu wako baba tebana bakujja wano yanguwa omusajja buno buzibu
sina kyendi
sajja kwata agala kumpambya wano bana basajja siba hizo mweziri yanguwa sijja kubalamu kansubireze Dale.